Thanks so much.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Again, good morning to everyone. I understand that there may be some interns here from the Office of the State Auditor, and if so, we greet y'all. We will hear the next case, which is State versus Dobson. We'll hear from the appellant.
Thank you, Your Honor, and good morning again. I'm Benjamin Call on behalf of the defendant, and I'd like to reserve 10 minutes of rebuttal this time. Thank you. I'd like to pick up where we left off because, as far as I understand it, as to the one issue that the court agreed to hear in this case, right, whether two odors together can serve as a per se rule, there's no disagreement. As I read the state's brief, assuming this court does not create a single odor per se rule, the state agrees that there'd be no basis for creating a double odor per se rule. And if I'm wrong, Mr. Dunn will correct me.
I'd like to explore that a little bit. Why do you not see that as an additional factor when you have the cover scent or whatever it's called?
Oh, it absolutely is, Your Honor. I'm not saying, and I think this is a point maybe of confusion created by the amicus brief. I'm not arguing, I've never argued that the police have to ignore anything, right? Whether it's the odor of cannabis, the odor of cologne, somebody's answer, the way, whatever it is, right? They can observe the facts and do their job. What I do recognize is that because we have legal cannabis now, in terms of marijuana investigations, it makes their job a lot harder, right? They cannot keep enforcing the marijuana laws as easily as they could before the legislature made this change. And while I'm sympathetic to that, right, the fact is it's not mine, and frankly, it's not this court's concern about whether their job enforcing marijuana laws now is harder, right? That's the decision of the legislature, right? And when the legislature was still contemplating this change 5 years ago, right, the law enforcement community, they realized that, right? They realized this is gonna make it really hard for us. It's gonna make it so hard that marijuana will be so widespread that it will be as if the legislature had done a de facto legalization of marijuana, right? That's the term they keep using. They used it then in their press release and their plea to the legislature. They use it now in their brief to this court. But the key point here, the key point, and maybe separation of powers isn't the right way to put it because yes, of course, what's legal is still legal, what's illegal is still illegal. But the point is, as a matter of policy, if North Carolina is gonna have what they call de facto legalization of marijuana, who gets to make that choice? The policy setting branch of the government, right? They call it de facto legalization, The legislature has a different word for it, a different term, right? They say we're creating a cash crop. We're creating a new boom economy, right? And so the law enforcement community, when they realized back then, you're going to make our job a lot harder, they went to the legislature. They said, these laws are going to handcuff us, so please change these laws. Change these laws so that we can still keep our superpower, that as soon as we smell cannabis, now whether it's legal or illegal, that we can still do what we used to do back when it was always illegal. We can make snap judgments, we can exercise our discretion, like Mr. Dunn said. Even though now it can be legal, we still want to always treat it as illegal. And the legislature heard from them and heard from the other sides, right? They asked for a legislative fix. They said, okay, create your CBDs and your oils and your edibles, but make smokable hemp illegal. Texas did this, right? And Texas has legal cannabis, but they do not have legal smokable cannabis. So there, although they still have some legal forms of THC-containing products, if you smell cannabis, then you know it has to be the smell of something illegal. That's what they wanted. That's why they went to the legislature. And the legislature, it's in my briefing, it was in the news reporting at the time, the legislature said, well, no, we're hearing other voices, right? The farmers, they say if we don't let them grow and sell smokable hemp, it's going to hurt their bottom line. So again, what you call de facto legalization, we say, well, we're making a policy-based decision about which direction North Carolina is heading. And we're moving forward. We're evolving. And so if that means you can't keep policing marijuana laws like it's 1980, I'm sorry, but that's what you're going to have to do. You're going to have to evolve as a police force. You're going to have to figure out new ways of enforcing the marijuana laws. And if it's harder, and if that means maybe, right, that some people get away with possessing or smoking marijuana, that's the decision for the legislature. And they said that they're fine with that. Why? Because we're making money. We have a cash crop. It's a boom economy. We can all walk out here and go to a handful of different stores after this is over and go buy legal cannabis. That's the vision for our state that the legislature has. And so that's why if this court gives them what they want, if this court lets them keep their superpower, you're undermining that very carefully considered legislative choice, period. And the Cisco case, the Arizona case that you asked about, is a perfect example of how that plays out. I think if you read it closely, by the end, they say in that case that it is a totality of the circumstances ruling. And the odor is obviously a factor, but another factor is the fact that in Arizona, unlike here, the Arizona legislature created a very, 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 very narrow class of legal cannabis, right? And you can only legally possess it under very narrow circumstances. That's not what our legislature did. They tried to get our legislature to do that, right? They asked our legislature to narrow the circumstances where smokable cannabis, right, the smelling kind, this kind, that kind of cannabis should still be illegal.
Well,
but it's not.
As I disagreed, or we had a friendly disagreement about that Arizona case, I did not see it as a totality of the circumstances, although I didn't see them reject that. What I read was an adoption of, I believe, and these are my words, odor unless. And I guess, framed that or looked at that because they had medical marijuana, and the unless would be very fairly simple to show your card that you had medical marijuana. Right. And so I did not see that particular case turned on the totality. It was really, the way I read it, of embracing an odor unless, which I guess we could frame it as totality, but the presumption was they had probable cause unless the other, unless the person being questioned or being detained could show otherwise there on the spot. Right. So I did not see it as applying totality to that situation. And I will certainly state that they did not abandon the totality, but I think they tightened up or made clear that odor could be, and I think Justice Deetz has asked this question a number of times, could be enough in those situations. As a matter of fact, the presumption, the way I read the case, was it was enough unless. And so so that's my view. So I suppose we have three different views of that case here, right?
Well, I think, yeah, I agree, right, that the narrow, right, the fact that it's medical marijuana there, that it's only very narrow circumstances in which it can be legally possessed was front and center in their analysis. I think by the end, they did use the term totality of the circumstances to make it clear that they were not abandoning that rule. But again, sort of the narrow circumstances there are very important to compare to the broad legality of cannabis that we have here. Because as you point out, in Arizona, if you legally possess it, you have to comply with certain regulations and rules. And so if you're pulled over and the cop smells it and he says, "What is that?" you say, "Here's my license, end of story. Give me my speeding ticket, I'll be on my way, thank you." Right? But Mr. Dunn just told you that if that same situation happens here and you get pulled over for speeding and the officer says, "What is that?" and you say, "Oh, it's actually legal cannabis," even if you have a receipt, they can ignore that each and every time. Mr. Dunn said it's a matter for the officer's discretion. And here's the thing.
But isn't it true, at least in this case, well, and we have others that will be before us, you've already argued one, that I did not see in any of the facts where any of the detainees said this is legal hemp, that I did not see that. Did I miss that somehow?
Well, to Sheen, the first case, Your Honor, it's a key point, and I'm glad you brought it up. Because under their theory, the law enforcement doesn't even have to tell you that they're taking warrantless investigative action based on what they smell. That's exactly what happened to Mr. Sheen. Again, this is why the trial court was so troubled by what the officer did. They saw the car parked. They knew it was a poor neighborhood. They walked up. That's when one of the two, not both, one of the two smelled the smell. And within 10 seconds, without saying a single word about why, they had my client in handcuffs.
Counsel, if you would keep to the facts of this case during this hour, please.
So in Dobson, the car was pulled over, right? They were trailing, they had their eyes on the car because they had seen a handgun sitting in the car. The car was parked in a downtown social district. They say, well, that's not good. We're worried about handgun safety. They follow the car, they pull over, pretextual stop. They talk to the driver, they find out immediately that the driver is an officer of the law.
So you said a pretextual stop. Is that in the record somewhere?
I believe it is, Your Honor. Well, I mean, there was a traffic violation, but they weren't concerned about the traffic violation. They were concerned about the handgun.
But they pulled him over for a traffic violation, and I think there was a finding of fact by the trial court that in fact had occurred.
Speeding.
Yes.
Yes. So they find out immediately, all right, well, there's no problem with the gun. The gun belongs to an officer of the law, right? And then they bring her out, they have the conversation, and they have a conversation about the odor. Because they just left a nightclub. And the officers say, it's in their body cam footage, they say out loud themselves that they suspect, because it's so faint, that the odor that they smell is just something that stuck to these folks' clothes. Something that attached to their clothes when they were at the nightclub. And they talk about the fact that, yeah, people were smoking at the nightclub. And this is in the Court of Appeals decision because we had a dispute about those findings of facts about that particular conversation about what the driver said. The Court of Appeals sort of assumed arguendo that the defense was right about that when the driver, all she said was, well, she acknowledged the existence of the smell, but said, well, it's not from inside the car. No one inside the car is doing something. So she guesses, just like the officers did, that it's a smell that originated at the club. Right? She acknowledges, yeah, people were smoking outside, like she smelled it at the club, but she herself, because nobody can know, she didn't know whether it was the illegal or legal cannabis. Right? That's the extent of the conversation she had. But again, I think the key point is, yes, that's great if someone tells the officer whether the cannabis they have is legal or illegal. But the key point is, under their theory, under the Court of Appeals ruling so far, the officer doesn't even have to say out loud that he's taking action based on the smell.
So suppose in one of these cases we hold that the standard is totality of the circumstances, that the Supreme Court has already instructed courts all across the country that that is the test. There's no mechanistic inquiries, no bright line rules. I think that's Florida v. Harris has been very clear. That's how the test works. And so we just say here, there's no per se rules, there's no bright line rules. There's just in every case totality of the circumstances. In this case, is there anything the Court of Appeals said that's inconsistent with that? I mean, they did say they were conducting a totality of the circumstances review. I didn't see them anything in their holding saying we reject that, we adopt some different test here.
Not explicitly, of course, Your Honor. So I think we have to infer by what is said in the analysis. And when you look at the de novo analysis in their decision, the only two factors that they mention are the two odors. Right? Obviously, there's other relevant factors. Right? If you're going to say that on a Saturday night, a group of friends that just left a nightclub gets pulled over and they smell of cologne, that the smell of cologne is an incriminating factor, then you have to balance that out with the fact that these folks just left a nightclub on a Saturday night. Right? And this is a key point about what totality of the circumstances means. Right? Because to hear it from the law enforcement community, to hear it from the Attorney General, right, it's just a scavenger hunt where all you're trying to do is just list enough things that may or may not be incriminating, rather than doing what we're supposed to and consider the whole picture, the way all of these pieces fit together. Mr. Dunn argues that it's relevant that when this parked car left from outside of the nightclub, it left the parking lot quickly. The fact that it left the parking lot quickly tends to point to the belief that the car contains evidence of marijuana-related crimes. I cannot figure out how to make sense of that. It does not. They also say, well, the reason why there's probable cause to believe the car contained evidence of marijuana-related crimes is because when the car was parked originally, the officers saw the handgun sitting inside the car, which of course is true. But so what, right? Let's even assume they said training and experience tells us people who use marijuana are more likely to leave their handgun sitting in a car. Okay, fine. But what happened after, right? What's the end of that story? They pull the car over and the driver says, I'm an officer of the law and that's my gun. Right? So the initial suspicion raised, assuming there was some, by the presence of the gun, was then dispelled. We have to consider the whole picture. We have to consider facts that both raise and dispel the initial suspicion. And this goes back to the point we were discussing earlier, Justice Barringer, is that if the odor is all it takes to raise the suspicion, then under their theory of this, there is no way at all that we can dispel the suspicion. Right? And that's, in my briefing, I cited two news stories about the arrest that took place on a bench in broad daylight outside of the Bojangles in Charlotte. And there was a couple, there's body cam footage in that story. There's a couple sitting on that bench smoking legal cannabis. And it's an example that I think really drives home why this point is so important. Because the officers' approach, and as they have done for decades, they treated that odor as the superpower that they need to infringe on these people's Fourth Amendment rights. And so as they're telling these people, stand up, put your hands behind your backs, the woman is screaming in protest. We just bought it right there. We just bought it at that store. Didn't matter. She got violently wrestled to the ground and arrested. And guess what? Finally, the substance was tested, and it was indeed legal cannabis.
Well, isn't the discrepancy or the difference here because there are two different standards that you're looking at? The first is whether or not there's probable cause to investigate or probable cause to arrest versus the standard required for a conviction. Those are two distinct things.
Yes.
And it seems to me that you're conflating those when if we're looking at is there probable cause to investigate, is there probable cause to arrest, that's a very low standard. And there may be innocent explanations for all of the conduct that you've explained here, all of the conduct that you've explained in this article that you bring up, and when you get to court or when you get to proof beyond a reasonable doubt, that's a completely different thing.
Absolutely, Your Honor. And if I've conflated them somehow, then I apologize. But of course, reasonable doubt, proof beyond a reasonable doubt doesn't come into play until trial. But I think, again, it comes down to whether we're going to satisfy ourselves with ignoring the default rule just based on this vague concept that probable cause is a low bar. Yes, of course, that's in the definition in many cases. Probable cause is a low bar. But if we're going to be satisfied with that as the reason to let them keep doing what they've been doing for decades, then we have to consider the real world consequences.
The problem, just to follow up on Justice Berger's point, that I have is it seems like that you're in effect saying, well, because the legislature has legalized hemp, effectively what you want us to do is raise the bar for probable cause. Is that what you're essentially asking us to do?
With all due respect, I think you have it backwards. I think they're asking you to lower the bar. Because again, the legislature knew what it was doing because the law enforcement community told them to their face. They said, if you do this, you're going to make our job harder. And so now, they didn't get what they wanted from the legislature, right? When they acknowledged that to get what they want, they needed a statutory amendment. And so now they're coming, right? It's like they asked to borrow the keys from mom, and mom said no, so they're coming to ask dad instead. The problem is...
The legislature, though, has left marijuana illegal. I mean, there's
yes, it has.
Big category of cannabis that's unlawful.
Yes, it has.
And so you argued earlier that would be veering into the legislative lane by upholding the search at issue in the first case. And I would assume you'd make the same argument here. But wouldn't we be veering into the legislative lane if we adopt a rule that essentially makes it impossible or practically impossible to arrest someone because of the smell of what might be or could be marijuana?
No, Your Honor, I don't think you're veering out of your lane by doing that, right? Because again, the question is who gets to decide, right? Who has the policy setting authority to decide how hard it should be to arrest somebody or to investigate someone warrantlessly for suspicion of marijuana-related crimes, right? And that, I think, is the key point, that that's a policy choice that should be made by the policy-setting branch because they knew what they were doing because the law enforcement community told them. They said, you're going to make our job harder.
Would you agree that we have a widespread problem with people purchasing, smoking, possessing illegal marijuana?
Problem?
Yeah.
No, I don't think it's a problem, Your Honor.
Would you agree that there are a large number of people who engage in that illegal activity?
Sure.
Okay. So I'm back to sort of the point that I was trying to get at the beginning of argument in the last case, which is, yes, now we have a category of products that have the same smell. They're legal, but we still have this category for which the smell is illegal, and probable cause only requires a fair probability. And so I'm struggling to see how the legalization of the items over in this category, the hemp category, eliminates that when I think it's pretty well documented and well known that there is widespread use of illegal marijuana.
I don't think there's any question that a lot of people use illegal marijuana. But this court's job is not to try to figure out ways to help the police enforce marijuana laws, even though the legislature changed the marijuana laws. Right? The legislature changed the laws that you're talking about. Yes, marijuana is still illegal, but marijuana doesn't mean what it used to mean. Right? That is the important change. And I think as a matter, it's a policy decision. Let me step back. The legislature, at least in the news reporting, really emphasized the fact that they were creating legal cannabis for financial reasons. Right? They wanted to create this new economy where people could buy this plant, use it, and possess it. And they knew that when they did that, They would be making it more difficult for police officers to keep acting the way that they have for decades. Another reason why the people would have chosen to do that is because of the very reason that the Attorney General himself has described and is describing right now on his own website. Right? The Attorney General himself has acknowledged that with the level of power that they've had for decades, based on the odor of cannabis, the police abuse that power. They use that power to discriminate against North Carolinians based on the color of their skin. And so right now, on his own website, the Attorney General acknowledges this is a problem. Yes, a lot of people use marijuana in North Carolina. As the Attorney General points out, black folks and white folks use it at the same rate. And with the level of power that police have had for decades, where have we gotten? Black folks are 300% more likely to be arrested. So I think it is well within the legislature's policy-setting authority to decide, well, okay, if what we're doing, if creating legal cannabis is going to make it harder for you to keep doing that, then so be it. Then it's time for the police to evolve.
Counsel, let me ask you a question. This is a little bit different situation. Guinness has made Guinness Zero,
Yes,
which is blasphemous.
agreed.
But let's say at 2 o'clock in the morning, someone had found a gun exposed in a vehicle, and walking from a club is an individual chugging down a Guinness. Not that this would be the right way to drink it, but chugging down a Guinness Zero, but doesn't see the can. Would the officers be within the law to stop that vehicle, whether the driver was white or black?
To stop the vehicle.
Stop the vehicle.
Yes, sure.
And there's no way to distinguish from those facts a regular Guinness or a Guinness Zero.
Correct. Okay. But then we have to keep going there.
Well, I said that a little bit different situation.
Right. Wait, well, but I think it's a poor analogy with all due respect, because let's say you have the traffic stop. Let's say you see the can, but it's got a koozie on it, so you're not sure if it's, you see it's open, but you can't tell if it's a zero or if it's the real deal, right? The question is, again, because probable cause inquiries have to be case specific, right? That's why we don't have mechanistic box checking, bright line rules, right? What is an officer going to do in that situation? And I would respectfully submit, as a matter of discretion, the officer is not going to take everybody out of that car, handcuff them, and then toss the entire car to search for evidence of Guinness-related crimes. Right? That is the key difference. That is the key difference. And the other key difference is the legislature didn't just pass a law to specifically create Guinness Zero. Last key point I want to emphasize is, other than Arizona, every other highest court of the states that have addressed this same issue regarding the significance of the odor of cannabis when legal cannabis coexists with illegal cannabis, every single one has come down on our side of the argument. Every single one has reaffirmed that you cannot just rely on the odor, that you have to consider the totality of the circumstances. That reason alone, if this court rules in favor of the government, North Carolina would be a national outlier on this particular issue. Thank you.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court, Zachary Dunn here again on behalf of the state. As with Sheen, the case directly before this one, if the court holds that the odor of marijuana standing alone continues to supply probable cause for a search, then this case is over. If this court does away with Greenwood in our position, or if this court determines that Greenwood does not hold what it has been understood by the Court of Appeals to hold, then this court should just simply hold that the facts and circumstances of this unique case gave rise to probable cause. And I do want to start with the issue that this court granted discretionary review on, which is this so-called double odor rule. It's our position, reading the Court of Appeals opinion, that the Court of Appeals did not create a double odor rule. The trial court did not purport to create a bright line double odor, which is the odor of marijuana, cannabis, plus a cover scent such as cologne. And the Court of Appeals did not create that rule either. That is not a part of North Carolina jurisprudence, and we're not asking for a bright line double odor rule. The confusion, I think, comes with the way that the Court of Appeals opinion below was crafted. And in that case, or in this case, excuse me, the entire analysis was dispelling defendants' erroneous assertion about an earlier Court of Appeals case, State versus Cottrell. And, defendant framed the issue in his reply brief at the Court of Appeals, and as the Court of Appeals held in its opinion, quote, "The ultimate disagreement between the parties is simply whether the totality of the circumstances supported the trial court's conclusion that probable cause existed to search the car." And so the Court of Appeals conducted a totality of the circumstances test.
I hate to take you off your train of argument, but how does the state respond to the argument that the legislature, in legalizing hemp, intended, because that's what I understood the argument to be, intended to make it more difficult to enforce the legal prohibitions against marijuana?
We don't think that that's the case, Your Honor. Of course, when we're looking at what the General Assembly did, we have the statute that they enacted. They did not purport to change the probable cause analysis in that case, or in that statute. The question is simply, after the passage of the Industrial Hemp Act, because again, this case happened in 2020 before quote-unquote full hemp legalization. So after the passage of the Industrial Hemp Act, whether probable cause still existed. There's no legislative intent that I've read, and I've read the statute, of course, that said that we as the General Assembly are intending to make it more difficult for law enforcement to prosecute marijuana crimes. So we do not agree with that position, Your Honor. Speaking again about the Court of Appeals opinion in this case, the Court of Appeals merely rejected defendants' argument about Cottrell and held that the totality of the circumstances here gave rise to probable cause. And I do want to speak about the other facts and circumstances of this case, the first being the firearm. And it is true that once the vehicle was stopped, the driver of the car said, "I am a law enforcement officer and that is my gun." I believe it was a woman, and I believe she was a correction or probation officer. But the firearm was not, holstered on her body. It was left on the console of the vehicle. So, of course, taking in the totality of the facts and circumstances, that is a relevant fact. This is not a gun that's holstered by a law enforcement officer. It is a gun that's sitting on the console of a vehicle. In addition to that, we have the odor of marijuana and the odor of a cover scent. As the discussion with my friend discussed, those can be facts in a totality of the circumstances. And then we have the law enforcement who pulled over the vehicle before seizing the defendant in this case, ran his criminal history, and this is at page 20 of the transcript of the suppression hearing. They discovered that defendant was a convicted felon and had recently been charged with assault with a deadly weapon with intent to kill, inflicting serious injury, along with possession of a firearm by a felon. So we have a firearm and someone who is a convicted felon. And at that point, they took the defendant out of the vehicle and discovered the marijuana. So this is, even if this court does not want to reach the Greenwood odor alone case, issue in this case, this court can simply hold that those facts and circumstances gave rise to probable cause in this case. in between arguments, as I was sitting down and not standing here, I did have a thought about your question, Justice Barringer, about state versus Cisco and how the state squares its position in these cases, because this is potentially an odor alone case as well, with Cisco, which Your Honor read as an odor unless. And our position is, the odor unless is odor unless you show a medical marijuana card. And medical marijuana cards, I'm not, extremely detailed in the facts and circumstances of Arizona medical marijuana law, but generally you have to get those from a doctor. And so that would dispel the suspicion, unlike a receipt where anybody in the whole state can go buy some legal hemp and then keep that receipt to attempt to dispel probable cause.
Which was the point I think Justice Allen raised.
I believe so, yes, Your Honor. I did want to talk about, so we discussed in the prior case the two cases, Cisco and Moore, that are on our side, Cisco being from the Arizona Supreme Court and Moore being from the Indiana Court of Appeals. The defendant argues that every other state outside of Arizona, the highest court of the state Supreme Court, has come down on his side. And his brief cites, I believe it's 4 different states, which is Michigan, Pennsylvania, Massachusetts, and Minnesota. And the facts and circumstances of the legality of marijuana in those states is just vastly different from here. So I did want to discuss them and dispel the notion that we would be a national outlier. Michigan, it's the Michigan versus Armstrong case. In that case, the legislature had passed full legalization of recreational marijuana. I think this would be a very different case if our General Assembly had passed full legalization, which it has not. Pennsylvania is the same way. Pennsylvania legislature had decriminalized marijuana for recreational use, and a person could have up to 30 grams of cannabis flower, 500 milligrams of THC, and 5 grams of concentrate for recreational purposes. So again, that case just doesn't apply to the facts that we have here. In Massachusetts, it's the Cruz and Overmeyer cases. The state had decriminalized less than 1 ounce of marijuana for recreational purposes. So again, these are all states that had some form of recreational marijuana, which is not what we have here. And I think this case would be very different if we did. I think the best case for defendant is the Minnesota case, which is Torgerson. It's from 2023. But it's still very different from the legal landscape that we have here, which at the time of this crime was industrial hemp, not quote-unquote full legalization of hemp. At that time in Minnesota, a person could have either 1, industrial hemp, 2, medical cannabis, and 3, 42.5 grams or less of marijuana, which was a petty misdemeanor, which Minnesota law defined as, although it is an offense, it is not a crime. So there's no evidence of a crime in that case. And again, so that is just very miles apart from what we have in this case and in this state, where we do have, in 2020, some limited forms of industrial hemp, as long as it is produced and used under the rules that were existing at that time. But the notion that we would be a national outlier is just not correct, Your Honor. The cases that my friend cites are extremely different from the facts and the legal landscape that we have here in North Carolina.
Can I ask you quickly, before you're done, about this alternative ground? I just want to make sure I understand. So the officers see a handgun in the driver's side, I guess that little spot you can stick things on the side of the door, right?
I believe it was on top of the like above the driver, the wheel, but it might be.
So wherever it is, it's somewhere on the driver's side where the driver can obviously reach it and access it.
Correct.
And the defendant is in the back passenger seat.
That's correct.
Right. And so if the officers have reasonable suspicion to extend the stop and ask the defendant to get out of the car, there's certainly going to be probable cause for the arrest, because the officers saw what they thought was him hiding something with those cups, and so they would have patted him down to see what that was, and they would have found the gun that he actually had. But to get there, your argument is there was reasonable suspicion once they realized that he was a convicted felon, that he was in possession of the gun in the driver's seat?
probable cause, but yes, we have,
Oh, you only need reasonable suspicion of
well,
them to stop, right?
correct.
Because all you needed to do was tell him get out of the car, and then they would have seen the strange, maybe hiding something.
Yes, Your Honor, I apologize.
But
Yes, we have the odor and a cover scent, plus a gun in a car with a convicted felon. We think that
But the odor and the cover scent have nothing to do with possession of a firearm by a felon. So what I'm trying to figure out is your argument on this alternative ground would be the gun in the driver's side front part of the car might have been in the possession of the defendant in the back passenger seat.
correct. And the odor of marijuana and the cover scent, although not directly related to possession of a firearm, it is still indicative of criminality, excuse me. And so we think all of the facts and circumstances on this alternative argument, you put them all together and you get probable cause, at least reasonable suspicion. Yes, Your Honor. Those are my submissions in this case. Unless there are any further questions, we would ask this court to either reaffirm Greenwood or, in the alternative, find that the facts and circumstances of this case gave rise to probable cause. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I'm wrong a lot, but I don't understand the totality of the circumstances argument here, or I think where you were going, Justice Dietz. Mr. Dunn just said that there was enough evidence that was indicative of criminality. Indicative of criminality is not what it takes to exercise a warrantless search based on probable cause. It has to be specific. It has to be individualized. Again, this is another important aspect that's baked into the definition of probable cause. So the question in this case was whether there was probable cause to conduct a warrantless search for evidence of marijuana-related crimes. Not whether there was probable cause to believe that these were bad people. So the fact that the officer didn't have her sidearm on her hip, but she had left it on the dashboard. I think if you look at the video, the officers thank her for that because that's the way you do it, right? So as to not scare the officers walking up to your window. You have a gun, you put it out and open so they know that it's there. She was doing the right thing. So how does that make it more likely to believe that this car contained evidence of marijuana-related crimes? The prior felony conviction, likewise. Felony for what? Tax evasion? We have no idea. And they brought this point up multiple times in the briefing, and I've explained this, and it still gets ignored. But if you're going to use a prior conviction as an incriminating factor in a probable cause analysis, then you have to conduct a staleness analysis to determine whether this prior conviction from 20 years ago is going to be relevant to the question at hand today. The trial court no court ever did that analysis because I don't think we even know when or what this felony conviction was. So the felony conviction cannot be relevant here. It cannot be relevant.
Well, I understood the relevance to be maybe instead of it being the probation officer's gun, that the officers reasonably could suspect that the defendant had said, here, pass this up and for our safety, put it in the driver's seat where they could see it, but it's my gun.
I think she immediately claimed it as her gun. And I think she was asked, is that your work gun? And she said, no, it's my personal gun. And then thereafter, there was no conversation whatsoever about the gun. Nobody was worried about the gun.
Well, they're still worried about it because the officer, one of the officers is at least in the back of the car in a position in case there is gunplay. Isn't that right?
Well, I think they were doing what they normally do, was kind of keeping an eye on these folks that they didn't know in this car. Whether they were doing that specifically because of the probation officer's gun, I wouldn't know, Your Honor.
Well, the finding of fact says the driver states her name, stated she had credentials and a handgun on the dashboard, and then it says Detective Alice took a cover position at the right rear passenger door. Okay. So that would be in response to the gun being present.
But again, I still don't see why it's relevant to the question of whether there's probable cause to believe. I mean, of course, safety is always an issue, and no one is saying officers can't take actions to protect their safety, right? But the presence of marijuana-related evidence has nothing to do with personal safety. There aren't any other questions? Thank you again very much for this opportunity.
Thank you, counsel. Mr. Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 45 minutes. God save the state